Hello, this is Matt on the Moon Lambo channel, and this is a terrible day. It brings me great displeasure to report that the SEC has won. They have defeated LBRY in their lawsuit, and the judge in that case has issued a motion favoring the SEC's motion for summary judgment. So it's over, the SEC wins. Now, I say that, of course, I don't know what a next step might be in terms of appeal, so there very well may be additional fight to come. I just don't have specifics on that to this point. I haven't seen anything. If anybody's talked about it, maybe I just missed it. I haven't seen anything. I'll be happy to report on that in the future as additional news breaks. But I'll tell you, this is a bad ruling. And it's not that the judge got literally everything wrong. I would never make such a silly assertion. But there are some key problems with what came down here, including a misrepresentation by the judge in terms of the Howey factors. Now, I'm no attorney, and I don't pretend to be one, but I'll point it out as in due course as we go through this video here. And also, the judge acknowledged in a pretrial hearing that there is not sufficient case law to cover this. So, like, a couple things. Judge said that he didn't want to create new precedent. He wanted to rule based on existing precedent. So you know what that means, given that, as the judge stated, there's not sufficient case law to cover an instance like this. That means that the judge decided that he was going to put the square peg in the round hole. And he was going to make sure he did that because he was not going to create new precedent. And in doing so, he came down with this ruling. And it's almost like he might as well say that oranges themselves are securities. He comes dangerously close to doing that. But in the end, ultimately, he just pretends like there's not some sort of issue of what the token itself is by the nature of it existing. That is not discussed, period. Well, how the hell do you move forward in the world of crypto and blockchain without a ruling on that? And so this judge really, I just think he was very uncomfortable in the way that he was going to, the fact that he had to even deal with a case like this, and didn't want to stir the pot too much. And so he put the square peg in the round hole, even though he understood that that's exactly what was happening. That's dangerous and really unfortunate. I'm going to share with you perspective from a few attorneys within the XRP community. I've got a lot of stuff from attorney John Deaton on this. And also, you may be wondering, what does this mean for the Ripple case? Well, it's going to have an impact, but I don't want to overstate that. What I presume is going to happen is that the SEC is going to file a new legal brief in the SEC v. Ripple case and point out their win here and try and use some of the arguments that from the judge in this case to make assertions. And they're probably going to conflate a bunch of stuff because they're disingenuous pricks. But they're probably going to do that. So to whatever degree that would impact the thinking of the judge, okay, there, it impacts there. But this is not binding precedent, so there's good news on that. And I did print this thing up. It was only 22 pages, and I'm going to share with you some thoughts from a few specific things I did highlight. But honestly, most of this was I'm not even going to cover because it's mostly just like background. I think over half of it was just like the background of the case and specifics and the distribution of the LBC token and all sorts of stuff like that. I really was just wanting to focus on the opinions that the judge had in this case, and he didn't have that many opinions, which was very surprising to me. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say, all right? I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Also, I want to note that this is it has harmed financially holders of the LBC token. That's the LBRY credit token. Here you can see as soon as the ruling came out just this morning, the price just fell off a cliff. It's currently down 34.2% within the last 24 hours. I was checking it earlier today, and it was down over 38% at some point a bit earlier today. It's disgusting to see this. It really burns my biscuits to see this here. And so here's the tweet thread from the official LBRY account. LBRY wrote, "We lost, sorry everyone." And that was a standalone tweet, and then they added to that and wrote, "We're going to lick our wounds for a little bit, but we're not giving up. We've got a bright team, tens of millions of pieces of content, hundreds of thousands of creators, and one of the most popular Web3 apps in the world. The best is yet to come." The full ruling in the SEC v. LBRY case can be read here, and then they provide a link to it. And then Jeremy Kauffman, who is the founder of LBRY, wrote, The SEC v. LBRY case establishes a precedent that threatens the entire U.S. cryptocurrency industry. Under this standard, almost every cryptocurrency, including Ethereum and Doge, are securities. The future of crypto now rests with an organization worse than the SEC, the U.S. Congress. And then there was also this from the official LBRY account. They wrote, and I'll censor this, the most effed up part of this whole situation is that even after 5 years of fighting and a court ruling, we still honestly do not know how to legally launch a public blockchain in the United States. Does anyone? And so think about this. Folks, it's not just that there are penalties, and I'll tell you right now, since the SEC won, there's going to be disgorgement of everything that was earned through the selling of the LBC token, as well as penalties on top of that. And so even after that, what's the go forward method? There isn't one. Like, what do you do? This didn't provide any clarity. This didn't help anything. How do you move forward with LBC? And that pisses me the hell off. This is not remotely reasonable. This shouldn't be happening to LBRY. And by the way, and I'll say this too, there are some people, and I don't want to be hard on LBRY. I'm a fan of LBRY. I'm supportive for sure. I'm just going to cover the news as it is. There are people that are, rightfully or not, and maybe it is right, they're critiquing the LBRY's approach in this case, stating that they didn't put forward a sufficient defense of their position. And I'll get into why as we go through the video, but I did want to mention that as well. Shout out and credit to James K. Filan, attorney and member of the XRP community, for sharing this legal filing, as well as attorney John Deaton's crypto law organization. I am going to come back to that in just a second. I just want to make sure I give the shout out before going further, though. And upon this news breaking, here's one of the first things that attorney Deaton had to say on this. He wrote, "This, unfortunately, is a total win for the SEC, as the judge does not distinguish secondary market sales independent of LBRY or future sales versus past sales. Get ready to vomit, with Gary Gensler and the SEC using this case as an example to move forward against crypto." Yeah, so pause to note here. Like I said, I read this whole damn thing. This judge tiptoed around the edges of all the important issues and just didn't address it. Judge could have addressed them, could have talked about the nature of a token existing, how that isn't a security, could have talked about that. Absolutely, just didn't. Could have talked about, okay, what does that mean for secondary market sales in the United States? What does that mean? Could have talked about that. Didn't talk about that. There is no clarity. He just basically noted that the totality of the scheme represented an investment contract, aka so a security. That's effectively what you'll see as we go through. And then attorney Deaton also said, Crypto Law, which is his organization again, Crypto Law tried behind the scenes and publicly to get more attention to this case. We interviewed Jeremy Kauffman, whom I am confident won't stop fighting. This case won't change the outcome of the XRP case, so don't let it bring your spirits down. The fight continues. Yeah, and I'll note here, and you'll see as we go through, the Ripple case is markedly different. The way that the facts and circumstances are different to certain degrees, but also it's markedly different the way that Ripple is defending itself, especially when it comes to prongs of the Howey test and all sorts of other stuff. So we'll be getting into that as well. Attorney Jeremy Hogan wrote the following: LBRY fought the good fight but lost at summary judgment. The judge hung his hat largely on the fact that there were essentially no use for the tokens at the time of the sales. I would expect this case to make its way into the SEC's final brief in the Ripple case. And then somebody named Swish wrote the following, and this is just utter nonsense, but I'm only covering it because attorney Deaton responded to this. This guy named Swish wrote, "Ripple is now going to settle. XRP was and now is a security. It doesn't matter what these 12 amicus briefs state. The judge has a clear legal precedent. This is absolutely devastating for Ripple, XRP, Cardano, XLM, and the rest of crypto." Now, I'd love to rip that to shreds myself, but I'll just let attorney Deaton do it. Attorney Deaton says, "One federal judge seated in a different circuit is not absolutely devastating to XRP. Judge Torres doesn't even have to read this opinion. As a lawyer, for you to say the judge has clear legal precedent is total FUD, and you know it. It's not precedent by definition. Will the SEC cite it and argue its persuasive authority? Sure. And Ripple will argue its non-persuasive authority." And so there you go. And then there was also this. Somebody from the community wrote to Hogan and said, "Did the judge rule that the token itself is a security? What about sales of the token on the secondary markets? And Attorney Hogan said, the ruling was very general. The judge just said that LBRY offered, which means sold, LBC as a security. Okay, so that doesn't mean that the token itself is a security. The way the judge worded it is he's not saying that it's a security, but he's not addressing that. There is no way to go forward for LBRY as things stand now. Which is why it just pisses me the hell off. I'm sure it's upsetting everybody else too. And then there was this. Here's some of Attorney Deaton's earliest thoughts, and I have a separate thread from him where he broke this stuff, his thoughts down even further. But when he first started this thread, actually, he hadn't even read the judge's ruling yet, and so he wrote the following: "Haven't had time to read it, but I'm sure SEC will cite it in the reply brief due in a couple of weeks, and Ripple will distinguish it on the facts. This decision is in the First Circuit. The Ripple XRP case is in the Second Circuit and has different precedent, like the Upton case. This means that Judge Torres doesn't even have to read the LBRY decision. Obviously, a win for LBRY was preferred. I'll reserve my overall thoughts until I read it. I can tell you this: LBC today is not a security, regardless if it was when LBRY first sold it. I may do a live stream on crypto law tomorrow, page 16 to 17. I can assure you the SEC will cite verbatim." Pause note, I did see an update later. He is going to be doing a live stream tomorrow on crypto law, just so you guys know. I don't remember the time off the top of my head, but stay tuned for that. I'm going to be watching it. I don't know if I'll be able to catch it live, but I hope I can. If not, I'm still going to watch it. But anyway, but check out this quote. "Even if LBRY never said a word about it, by retaining hundreds of millions of LBC for itself, LBRY also signaled that it was motivated to work tirelessly to improve the value of its blockchain for itself and any LBC purchasers. Would lead purchasers of LBC to expect that they too would profit from their holdings of LBC as a result of LBRY's assiduous efforts." And that was the quote in there. So I actually highlighted this. I was going to talk about it later, but you know what? Let me just mention it now since it's fresh in my head anyway. And Attorney Deaton mentioned it here. When it comes to Ripple's escrow, people have been saying that this is what the SEC is going after. And I pointed out, and I'm right on this, it's just a matter of fact, that the SEC has not made the assertion that Ripple's large holdings of XRP makes it a security or that it applies to Howey. The judge here independently, in this case, said that it matters. So Judge Torres, in theory, could say that it matters in the SEC v. Ripple case. But I'm just telling you, the fact that Ripple's large XRP holdings wouldn't matter. They could have small XRP holdings. If they had any XRP holdings whatsoever, or if they had a small amount at some point and sold it all, and say they didn't have any right now, they'd still be screwed. It doesn't matter if it's what the quantity is. The point is they had it and they sold it. That's it. If they just held XRP and Ripple had literally never sold any, like what would the assertion even be? Like what could the SEC even sue? Like what would they be suing for? It's really unfortunate here. But so no, anyway, I'm just saying if any of you are worried about Ripple's XRP holdings being a thing, it's not the quantity. It's the fact that they ever sold any XRP at any point in time. That's it. The quantity, I see no evidence of that mattering whatsoever. And in fact, LBC, LBRY only held back 10%. So that's a problem there for them. That's what the judge found. Okay. So that's what I'm saying. The quantity doesn't matter. And the judge didn't even say that the quantity mattered. He just cited the quantity. And then Attorney Deaton says, it goes on, quote, "Simply put, intertwining LBRY's financial fate with the commercial success of LBRY made it obvious to its investors that it would work diligently to develop the network so that LBC would increase in value," end quote. "After all the amicus briefs, I'm sure the SEC is feeling good because they will cite the above language applies to Ripple. At the risk of coming off like self-promotion, XRP holders' amicus brief just became even more important than ever. Our brief, unlike other briefs, addresses some of the alignment language this judge is relying on, etc." And I'm going to circle back to some of that because I got a few notes. We will be coming back to that, but there's just a lot to cover here. But as far as like if you look at how the judge considered the Howey prongs, there's just what a train wreck. Now, there's an attorney here named Gabriel who is a general counsel at a company called Delphi Labs. And Attorney Deaton's been retweeting some stuff from him. And he seems to be a rather insightful guy. And so here's something that Gabriel wrote after the news broke. He said, "It's dicta, but here the LBRY judge reasons that even if team is completely silent about efforts, no promises, no contracts, but pre-mines tokens, that alone creates a sufficient expectation of profits from their efforts in common enterprise to pass the Howey test. And then he says, I think the judge's reasoning in this dicta is challengeable. It essentially counts the same facts, LBRY team owning tokens, as satisfying two different elements of Howey. If that was how the test was meant to be applied, why would these even be two elements rather than one? And so let's be clear what he's talking about here. And this is, again, one of the many reasons why this is a bad ruling. The judge did not do a good job judging, okay? So take a look at this part. By retaining hundreds of millions of LBC for itself, LBRY also signaled that it was motivated to work tirelessly to improve the value of its blockchain for itself and LBC purchasers. And so that's also part of what Attorney Deaton was talking about. But when you talk about the Howey test, and I'll actually pull it up on the screen a little bit later on, you'll see, I mean, what he's arguing here, again, just to be clear what Gabriel stated here, stating that the fact that there was the, well, here, let me just read it again. I think the judge's reasoning in this dicta is challengeable. It essentially counts the same facts, LBRY team owning tokens, as satisfying two different elements of Howey. Yeah, exactly. So, if you're talking about an investment of money, and then that also, because there was an investment money, means that there's now a common enterprise, because that's kind of what the judge is arguing here. So if one prong of the Howey test is satisfied, that means that another one is also satisfied. That is not how this works. Now, funny enough, I don't know if any of you caught this, but in the SEC v. Ripple case, the SEC actually argues that. They do. They cite that a prong is satisfied, therefore other prongs have been satisfied. And I'm paraphrasing, but that is what they've argued. I've covered it on the channel before. It makes no damn sense. And here, the judge on his own argued that, which is completely illogical. Isn't this just like, ugh. This is like, what do you do with this? I just can't believe this is real life. And then there was also this from Attorney Deaton. The LBRY decision is a very bad decision. It's why I've been talking about this case for the last year, and it is true that if the reasoning utilized by the judge was the law in the United States, it would serve a death blow, but it is not the law. So pause, and this is why you can sleep easy tonight. Although the judge ruled this is not some sort of binding precedent for all things crypto, it is not law. This is just one case that came to a conclusion, and it was not favorable, and there are definitely faults in the judge's logic. Definitely faults in his logic. You don't have to be a lawyer to see that. I'm not a lawyer, but I'm telling you, I got more than half a brain, and I know what a logical argument is. I know what an illogical argument is. The judge is just missing it here. And then Attorney Deaton says, it is one district judge's interpretation of the law as applied to one specific case. LBRY's lawyers did not contest Howey's second prong requiring a common enterprise. They did not ask the judge to distinguish between secondary market sales and direct sales by LBRY. Yeah, exactly. And so this is what I've seen a couple of attorneys, not just Attorney Deaton, bring up, is that the second Howey prong common enterprise wasn't contested. That's kind of a problem, perhaps, right? That's something that maybe it would have been wise to contest, unless they really agree that they're the common enterprise, but I don't think they do, because this is a decentralized cryptocurrency here. So it probably would have been good to push back, because the judge just found that that's the case. And there's only a few prongs in the Howey test. Push back on all of them, And then Attorney Deaton says, again, they did not ask the judge to distinguish between secondary market sales and direct sales by LBRY. See, that's the thing, too. And if you look at all the amicus briefs in the Ripple case, like multiple of them say you need to distinguish between sales that Ripple made, especially in the early years, fine, but that versus secondary market sales, that's an argument that wasn't even addressed here within the LBRY case, but in the Ripple case, it's on the table. So presumably the judge will address this, right? And then Attorney Deaton continues and says, in the Ripple XRP case, common enterprise is challenged. In fact, the SEC argued incoherently regarding the common enterprise. And at first, the SEC argued Ripple was the common enterprise, but when the SEC was forced to concede that XRP holders do not obtain a legal or financial interest in Ripple, the SEC shifted and through a so-called expert witness argued next that the common enterprise was the entire XRP ecosystem, including exchanges, vendors, merchants, and retail holders. But because, in part, XRP holders fought back and supplied 3,000 affidavits refuting this alleged expert, the expert backed down and testified that he might have come to an entirely different conclusion if he had known what we were declaring in those affidavits at the time he wrote his report. See for yourself how we made a difference. So the SEC abandoned its expert and moved for summary judgment without relying on its expert. Thus, there is no testimony about the XRP ecosystem being the common enterprise. Instead, the SEC did what it always does when it doesn't have a good answer. It focused on the token and claimed XRP itself is the common enterprise. The SEC literally claims that XRP itself represents the common enterprise and represents the investment contract with Ripple. The SEC's argument in the Ripple case is very simple. The SEC is asking the judge to substitute a but-for test for the Howey test. Of course, they don't frame it that way, but that is what they are doing. Quote, but for Ripple executives created the XRP ledger and XRP, there wouldn't be a secondary market for XRP. Therefore, all XRP are securities. Comparing LBRY is like comparing apples or oranges. Pun intended. Don't get me wrong. It's a S-word ruling, and I'm sure the SEC will make a huge deal to Judge Torres about it, and Gary Gensler might act as if the Supreme Court just handed down a ruling, but we know better. Yeah, exactly. So this isn't over. The fight's not over, and this judge it's faulty logic. It is not everything that the judge said, so I'm not going to overblow it, but there are some key things that should have made this go very differently, but it did not go very differently. And that's why, again, some attorneys are pointing out here, well, there are some other things that could have been argued that would have forced the judge, presumably anyway, to address this and perhaps come to a different conclusion. Maybe. But it's Monday morning quarterbacking, right? And then there's also this from Attorney Gabriel again. LBRY judge says, mixing consumptive and investment uses cannot be a loophole to the securities laws. This is what I predicted would be key factor for the judge. Many lawyers made way too much of Foreman case. There, consumptive intent was nearly exclusive. Right. And that's actually part of what I highlighted. I mean, maybe I can just tell, I really don't even need to, I guess I can, but I don't even really need to go through this to share all the ideas I wanted to share, to be honest with you, because there wasn't that much actual, in terms of the judge's thought process and logic as to why he came to conclusions. There wasn't that much in here, honestly. I'm not kidding you. It might surprise you because it's 22 pages. It was just a lot of history and stuff here. But I will tell you, so the judge, he's right. There can be an investment contract if there's a cryptocurrency or any asset that is purchased for investment uses, but also has utility, meaning consumptive purposes. That's true, it can be. But again, the problem being that there is no addressing a path forward. There is no addressing that there's no case law to handle a case quite like this, where what is the asset? It's not even touched. It's not even touched. And that is what's so big part of what's so frustrating about all of this. Because that's the issue, right? The judge has to know this. He just doesn't want to talk about it. Really frustrating here. And then there's also this. Or maybe I do one. I think this is something I actually highlight. I'll probably just come back to that. So Attorney Deaton highlighted that and from Gabe and said, Gabe called this one to the T. He got it more right than I did. I was at the oral argument and I thought the judge would fine for the SEC, but not so convincingly for the SEC. So Attorney Deaton and Gabe, they actually both thought that things were looking better for the SEC, unfortunately. And so that's why I've stated in the past, I was cautiously optimistic about this case. That's how I phrased it. I've always been a lot more optimistic regarding the SEC v. Ripple case for a number of reasons. But still, just kind of based on some of the questions that the judge was asking, I thought that he was his questioning pattern. I do think he was going down the right path. But the problem is, he just didn't want to. Again, he was so clear. He wanted to. It stands out so much now. How he just wanted to make sure that he's going by precedent, not precedent setting himself. And that here's the problem, because square peg and round hole. That's the big problem there. So yes, he had the right questions, but he just didn't want to do anything earth shattering. And so he didn't. He could have. And then there was this from Attorney Bill in the XRP community. It needs to be said that LBRY received no obvious support from the crypto community other than from people in the XRP community and LBC users. No amicus briefs at all. No support from crypto industry associations. LBRY fought alone for years and received a bad judgment. Ain't that the truth? Attorney Bill also said, I expressed my concern back in June about LBRY not challenging the common enterprise prong of Howey. I was correct. Big mistake. It is the SEC's weak point. They try to slip it by unchallenged with vagueness. They are not getting away with that trick with Ripple's attorneys. Well, that's true. So in the SEC v. Ripple case, that is a notable difference. In terms of common enterprise, yeah, that idea is... Ripple's legal team's going for it. If you've been following the case, you're aware of this. And then Attorney Bill shared this tweet from June 26, where he was noting his concern about the Howey test, specifically with having to do with common enterprise. Now let's jump into this, and this part should be pretty quick here because again I didn't highlight that much, but let me go to the bottom of page 8 here. Sorry, 1 second. Yeah, here we go. Okay, so right here. The First Circuit has broken the Howey test into 3 parts. Number 1, the investment of money. 2, in a common enterprise. 3, with an expectation of profits to be derived solely from the efforts of the promoter or a third party. Here, only the third component of the Howey test is in dispute. Did you hear that, guys? Out of the 3 prongs cited there. Only the third prong of the Howey test is in dispute, he says. Now, again, in Ripple's case, all Howey prongs are in dispute, all of them. Now, but also in the LBRY case, the judge is wrong here. The judge is wrong here. He literally said something that isn't true. The first prong is disputed. The judge here is saying the first prong is not disputed. But look, purchasing LBC for utility is not an investment. Think about it. If you're literally doing it for consumptive purposes, so it is in dispute. And LBRY did dispute that. So the judge literally stated something here that isn't true. And again, as I cited a few minutes ago, just because something has a consumptive purpose, I recognize that the law states that it can still qualify as an investment contract. But again, the underlying asset, that's what's separate here. Now let me move a little bit forward. Going to the bottom of page 16. So let me scroll down here. And this is a topic, I think I may have just touched on all these topics already, which is why I can probably get through this pretty quickly here. Yeah, here we go. By retaining hundreds of millions of LBC for itself, LBRY also signaled that it was motivated to work tirelessly to improve the value of its blockchain for itself and any LBC purchasers. There you go. So the fact that they hold LBC, I guess that means they're the common enterprise. I mean, that's kind of what he's getting at here. Doesn't it kind of sound like that anyway? But again, it doesn't matter if you had sold 5 of the tokens. You still did it. And we still don't have legal clarity, so they're still coming after you here. So in Ripple's case, again, I don't think the quantity of the XRP matters. The fact that they sold any at all is what the SEC is arguing about here. And then there's also this, page 17. Yes, right here. Check this out. LBRY's primary response to the SEC's claim starts with 2 generally uncontested facts. Number 1, LBC is a utility token designed for use on the LBRY blockchain, and 2, some unknown number of purchasers of LBC acquired it, at least in part with the intention of using it rather than holding it as an investment. Building from there, LBRY leaps to the conclusion that LBC cannot be a security even if LBRY offered it as an investment. LBRY is mistaken about both the facts and the law. So think about the way he worded that. Pause that. LBRY cannot be a security even if LBRY offered as an investment contract. Well, again, the token itself would not be. The token itself most certainly would not be. But on the next page, he also says, nothing in the case law suggests that a token with both consumptive and speculative uses cannot be sold as an investment contract. Yeah, exactly. So again, this is true. The judge is correct. You can have something that has consumptive use and is also an investment, and it can still be part of a scheme, an investment contract. So that is true. Judge is correct, but that doesn't mean the token itself is a security, and the judge ignores this fact. It's like, what do you do with this? It's just really disappointing. It grinds my gears, folks. So you let me know what you think in the comment section below. This isn't over. It's not going to destroy Ripple's case. It will have an impact to some degree because I'm highly confident of that. I just don't know that it's going to be substantial. We'll see. But the judge is going to be aware of this in the Ripple case, Judge Torres, and the SEC is going to try and make a big deal of it, but who knows. I'll go ahead and wrap up here, though. I would love to hear from you, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.